Good afternoon, Your Honours. This is case number IT 0484R77.13, the prosecutor versus Shefqet Kabashi.
Thank you, Madam Registrar. May I have the appearances? Prosecution first.
Good afternoon, Your Honors. For the Office of the Prosecutor, I'm Tom Hannes. I'm appearing with Alma Imamovich Ivanov. Ms. Corner is participating in an extended sitting in the Michos Tennis Stoyan Jablanica trial, and I'm standing in for her.
Thank you also for that explanation, Mr. Hannes. For the defense, I see that you are present, Mr. Kabashi. There is an audio link established with your counsel, and I'd like to verify whether Mr. Karnavas is at the other side of the audio link and whether he can hear me.
Good afternoon, Your Honors. I am on the other side and I can hear you.
Thank you, Mr. Karnavas. We'll then proceed. Mr. Karnavas, we already expressed that you would be accused for not being present. That has not changed. I now will proceed, first of all, with a Rule 15 bis statement. Judge Morrison is absent for urgent personal reasons this afternoon, and Judge Kwon and I have considered that it is in the interest of justice to continue to proceed despite the absence of Judge Morrison, pursuant to Rule 15 bis of the rules. There seems to be some noise on the line. If it does not get any worse, then we can continue. If it does get worse, I'd like a technician to have a look at it. We are sitting today to deliver the Chamber's sentencing judgment in the case of the prosecutor versus Shefqet Kabashi. And for the purposes of this hearing, I will briefly summarize the Chamber's findings. I stress that it is a summary only. The authoritative account of the trial chamber's findings can be found in the written sentencing judgment, which will be made available at the end of this session. This case concerns Mr. Kabashi's contumacious refusal or failure to answer questions as a witness in the Haradinaj et al. Trial, thereby committing contempt of the tribunal pursuant to Rule 77A, small I, of the Rules of Procedure and Evidence. On the 26th of August 2011, Mr. Kabashi pleaded guilty to 2 counts of contempt of the tribunal, and the trial chamber accepted his plea on the 31st of August, entering a finding of guilt. The trial chamber will now give a summary of its sentencing findings. It recalled that the 2 primary purposes of sentencing in the tribunal are retribution and deterrence, both special and general. The trial chamber considered the gravity of the offences and the totality of the culpable conduct. By contumaciously refusing or failing to answer questions as a witness, Mr. Kabashi deprived the Haradinaj et al. Trial chamber of evidence relevant for an effective ascertainment of truth in the adjudication of that case. The defense submitted that Mr. Kabashi's frustrations, his war experience and witness intimidation may have contributed to the refusal or failure to answer questions. Despite these submissions, the trial chamber found that any additional motives Mr. Kabashi may have had remained vague and could not be considered in determining the appropriate sentence. In mitigation, the trial chamber considered that, according to medical documentation, Mr. Kabashi suffers from post-traumatic stress disorder and that his medical condition worsens in a prison environment. The trial chamber further considered Mr. Kabashi's family situation in mitigation. Moreover, Mr. Kabashi apologized for his crime on the 31st of August 2011. While the trial chamber considered his apology genuine, it considered that the remorse expressed in this way was reduced in its mitigating weight by the fact that Mr. Kabashi had failed to come to The Hague to face the charges against him for more than 4 years. Having summarized its findings, the trial chamber will now give its verdict. Mr. Kabashi, would you please stand? For the reasons summarized above, this trial chamber, having found you guilty on the 31st of August 2011 of the following charges: Count 1, contempt of the tribunal by knowingly and willfully interfering with the tribunal's administration of justice on the 5th of June 2007, and Count 2, contempt of the tribunal by knowingly and willfully interfering with the tribunal's administration of justice on the 20th of November 2007, hereby sentences you, Mr. Kabashi, to a single sentence of 2 months of imprisonment. You are entitled to credit for the period of time you have been in custody, which amounts to 31 days. Mr. Kabashi, you may be seated. This concludes the delivery of the sentencing judgment, which will now be made publicly available. And before we adjourn, I would like to verify with Mr. Carnavas whether he has been able to follow the pronouncement of sentence.
I have been able to, Your Honor.
Thank you, Mr. Carnavas. The trial chamber stands adjourned.
All rise. Forgive me.